Hi, Matt.
Good afternoon. Is this Shamesh on the bell?
Yes, it is. How are you?
Hi, Shamesh. Good. How are you?
I'm well.
Good. Just before we continue, now as the last time, all of our calls are recorded and then filed against your complaint. So that being the case, are you happy to continue the conversation?
Yeah, that's fine. You're fine with me recording the call as well?
Of course. Sure. I think you did last time as well.
Yes, as I'd advised.
Yep.
So
Perfect. So,
now,
yeah, speak to me. What's happened? What's changed? I believe you said in your
yes,
email that you've gone into discovery, which I presume is part of the court case, and
yes.
you were
So
discovered.
I'm just bringing up my notes. Um,
Sure, of course.
you give me 1 second.
No. Just to make you aware as well, we release case file information from a secured system. I'm having a bit of IT trouble with that particular system, so I can't look it up at the moment.
Okay.
So
No,
if
that's
there is
okay.
something we need to reference, yeah, cool.
So uh, a couple of things for context.
Of course.
Before I get into the substantive matters. I had previously requested you um, what the process was for my colleagues to also be joined as complainants. Um,
Sure, yep.
do you formally require them to give me authority, or can you just
Yeah, typically we do, and I'm happy to arrange that with you after the call. It's typically a form that we send out, so I'm happy to email that to you as well.
okay? Yeah,
For the
please, if you could do
purposes
that.
of going forward.
And can they give me general authority for a set of complaints, or do they have to do it each time a complaint is made?
It's a very good question. I actually don't know the answer. I will find out for you though.
Okay, so let me tell you what has changed, firstly, since we had last spoken, um,
Of course.
and then I'll tell you what I think are the implications of it in terms of the complaint, and maybe you can um, advise me if you think otherwise. So,
Sure, happy to.
there's two major developments that have taken place since we last spoke in relation to the IBAC matter. The first is essentially a development that directly concerns IBAC and the admissions that the IBAC has made directly. The second set of developments concerns the um, Legal Services Board and Victoria Police, or the conduct that the IBAC failed to investigate. I now have discovered further information which clarifies how the Legal Services Board abused um, its improper coordination with Victoria Police to essentially generate a fraudulent complaint against my firm, because without a complaint they would not have had any jurisdiction to take any action, and because all the firm's clients were effectively me or entities related to me, they would have never received a complaint against the firm. So in effect, the police officers that the IBAC is now charging um, or criminally investigating to lay charges,
Okay.
they I had an elaborate plan um, through which I wanted to essentially um, shock them, and um, I had anticipated that that would lead to them internally communicating about the event, and eventually I could subpoena that. So I had planned So on the 3rd of May, after a couple of months of planning, and after we had transcribed the audio recording of the police's improper invasion of my premises, I sent around 5 or 6 people from the firm, 2 solicitors and administrative staff, to confront some of the police officers or whoever was on duty at that station at the time with the audio recording, and ask them questions, so on and so forth. I thought that would be unpleasant enough for them to then communicate with each other, and when I subpoena the emails, I would know who all were involved. It worked beautifully. But that evening, they contacted the LSP. The LSP then, for the first time, had a complaint against the firm. They communicated on the phone and decided to frame the complaint in a way that, so the only thing that they could come up with was that all 5 people that were there pretended to be solicitors, and only 2 of them were solicitors.
Okay.
Now,
That was the basis of the complaint.
yes, and it was totally manufactured because they first spoke on the phone, then the LSP basically got them to make that complaint, and because they were making fraudulent assertions. By the way, the interaction was recorded, so I have a recording of what was said when it was said, and I was on the phone when it was being said, and all my phone calls were recorded at the time as well. So essentially, the police officers later started backing out from making formal sworn statements. The Legal Services Board then had to constantly pressure them, and ultimately the police asked for what authority the Legal Services Board had, and then to essentially request information, and because the police investigation information is confidential under the Victoria Police Act, and then a statutory instrument had to be issued by the Director of Investigations. Now, all of this information was ultimately subpoenaed successfully after a few unsuccessful attempts. So this is, and on the 4th of May, the LSB issued a management systems direction to the firm immediately after, in relation to issues that, the apparent justification for it were issues that had been going on for several months, but they didn't have any authority to do anything about it.
Just to confirm, sorry, the date, May the 4th, is that
2021. 2022. Sorry, 2022. It's 20. So, and 3rd of May is when the people had gone to the police station. Now, this is where the IBAC comes in. So, as you would, or I suspect you'd be aware, effectively the IBAC had dismissed the complaint that I'd made against Victoria Police. They had, in fact, not even considered the complaint against the Legal Services Board, so that's something that I was a little bit confused about initially, but I've gone through all the complaints again, and because I had made a few complaints to them, for the specific Legal Services Board complaint, they hadn't even considered it. Now,
to make you aware, under their legislation, they do have a threshold for what complaints they consider, and they do they believe a threshold.
I know. I've effectively memorized the IBAC Act at this stage, I went through a very extensive trial where, anyway. So the point is this: after I started the judicial review proceeding against them, and then to illustrate the point that by the time in that proceeding, this was around the 4th of August 2023 that I had made the new complaint. IBAC knew enough about its mistakes that it wouldn't take the same decision again, because it would incur additional liability. IBAC then did not dismiss the second complaint, and they kept dragging it on until Justice Ganay came out with a decision when His Honor essentially expressed views that the IBAC, in his view, did not consider the complaint thoroughly enough, or did not take into account some important factors that they ought to have. After that, what the IBAC did is essentially reopened the first complaint instead of investigating the new one, and decided to reopen, or open rather, the complaint against the Legal Services Board. Now, I think this is common knowledge, but it is not lawful for an administrative body, or a judicial body for that matter, to recommence a matter that has already been finally decided, and unless there is a specific statutory entitlement that allows that. The authority that clarifies this in detail is Minister of Immigration versus Bhardwaj, BHARDWAJ. The citation for that is, just one second, I'm bringing it up. So the citation is 2002 HCA 11. Also in a more factually relevant authority, this is Cahill versus Commissioner of Legal Services, 2017 VSC 177. A similar issue had arisen where the Legal Services Board effectively decided to reopen a complaint that it had closed, and the court found that it had no jurisdiction, and it referred to Bhardwaj and a couple of other similar authorities. The only instance in which a matter can be considered, even though it seems that it had been previously settled, is when there was no exercise of jurisdiction. But even then, there has to be a certain set of circumstances that can permit the administrative body to allow that to happen, because it certainly can't be done for the purposes of fraud or fraudulently evading liability. What the IBAC did was they reopened the first complaint when I had not asked them to. I had made a fresh complaint specifically, and
which was the one you said earlier that
they've still not decided it.
Sure, okay.
Because they reopened the first one. Now,
So just for clarity, what was the outcome you put in the proceeding that included it in your second complaint or something like that, or complete investigating that instead?
so, okay, there's two elements to it. First is the the fact that I want justice. I've had a lot of things taken away, and I want people who were responsible to be punished. And in that sense, I want people who made mistakes at the IBAC to be held accountable for them. And that I want more than the practical benefits that most people would consider more important. And then the other thing is I want the practical benefits of the investigation to, have the police officers held to account and so on and so forth. And also I'm going to sue them for misfeasance. But the point is that what the IBAC did in terms of reopening the complaint was not only was it done to basically create the false impression that they had not improperly closed the first complaint, or the fact that their improper closure of the first complaint had resulted in an injustice. They wanted to evade accountability for it, because then they can't be sued in relation to that because they've finally reopened it, was going to be the argument. Now, after that, before they came out with a decision in respect of what they were going to do with the complaint, they had only decided to reopen it. They hadn't. So this was in April that we had spoken, and by that time they had decided to reopen it. They hadn't confirmed that they would investigate the matter by that time, and they had asked for a judicial mediation so they could convey the decision to me. Now, right then, that took place on the 7th of May. Yes. Now, I mean, it was fairly predictable that the only reason why they were wanting to have the confidentiality of the mediation was so they could, say matters that otherwise could be used against them. Now, during the mediation, basically, the IBAC offered to investigate the matters for me as settlement for my lawsuit against them. Okay. I told them that they had no authority to bargain with their statutory duty, and I would, they can do what they want. I would sue them if they do the wrong thing, and I wasn't very fussed about whether or not they were going to investigate the matter. I proposed terms for the closure of the matter, but clarified that just closing that matter did not stop me from suing individual IBAC officers and the IBAC as an entity for misfeasance, which I wanted to do and intended to do anyway. So right after that, they basically walked out of the mediation abruptly. They had been extremely keen. And then the following day, or 2 days later, they wrote to me without prejudice, and they basically clarified that the reason why they did not accept my terms to conclude the proceeding was that I wasn't giving them release from a claim of misfeasance, them and their officers. They put that in a letter. Yes, and they have no authority to do that because misfeasance is a personal tort. Well, this is like they're bribing. It's not bribing, embezzlement. It's like the IBAC officers in charge are embezzling from the institution to settle personal claims through the statutory body's resources. Not just that, they held the statutory function hostage because they delayed the announcement of the decision until they could have an opportunity to put that to me. And then when all was lost, after that, I basically told them that, um, I gave them some time to apply for an injunction to stop me from using the information conveyed through mediation and subsequent without prejudice communication. They did not want to apply for an injunction to stop me. I told them that I had an entitlement to use the information because it was being used by a government body for fraudulent purposes, and I set out the legal basis for it. They didn't challenge it. It's now in evidence in court proceedings, and I have indicated that it will go to the Victorian Inspectorate. So that communication confirms that they basically were using the mediation setup to settle claims of misfeasance. And now the next thing is this. After that, when everything failed horribly for them, and they had to, reopen the matter anyway because otherwise the court would have ordered them. So I'm saying, so they're now investigating the matter. They have decided to investigate the matter, I should say. So the complaint was successful. The problem now is that they have done that pursuant to a complaint that they had dismissed, whilst they are trying to give the fraudulent impression that the basis of reopening that matter is the fresh evidence or the additional evidence that I gave. So they're not saying that they made a mistake. They're not saying that they made a mistake. They're trying to imply that the additional evidence convinced them. They're not even saying that directly because it would be more incriminating evidence of fraud. But the problem is this: they had the audio recording of the police officers that day. That is the most consequential piece of information. And they had a lot more as well, but they had the audio recording. That's basically the smoking gun. Now, the problem they have is that they have in court clarified that it is not their position that they had made a mistake in dismissing the complaint. Okay? So, that's right. They're not saying, okay, all they have said is that they have not admitted that they made a mistake. They have also not said that they did not make a mistake. Do you understand?
Oh, I see. So they're implying their own positive position.
Yes. They're implying that they did not make a mistake without saying it. But also, when I'm saying that that's an admission, because the letter literally apologized for dismissing the complaint earlier and, taking this much time. And when I point that out, they're saying, well, they don't accept it's an admission. The problem is this: if they did not make a jurisdictional error, then they have no basis to reopen that complaint. Now, an investigator has been appointed at the IBAC. They've gotten in touch with me. My concern, among other things, is that even if they bring the charges against the police and have, I've already prepared all the evidence and so on. I'm prosecuting the police officers privately as well. But the issue is that the police officers will have a basis to set aside the investigation, and it will be a huge waste of everybody's time and the public funds because they never had jurisdiction to reopen the matter. So the only way they firstly, not every circumstance in which there's been a jurisdictional error will be such that the matter can be reopened. But the only circumstance in which a matter can be reopened is where a jurisdictional error has taken place, and the statutory provision empowers the statutory body to then take the necessary steps, or I should rather say, the statutory provisions do not stop the body from later considering the matter if they haven't considered it in the first place. But there definitely has to be a jurisdictional error, or a special kind of jurisdictional error, which comes from the failure to exercise jurisdiction. So it's a more specific kind of jurisdictional error. They're not saying they've done that. And by the way, the first letter that had dismissed the complaint, it had clarified that they had gone through all the information and they had decided that it did not, meet the public interest criteria and so on. So now there's another problem here, by the way, for them, which is that under the Australian privacy principles, the Victorian version of it, basically, the information that I give to IBAC can only be used for the purpose for which it is given, if it is personal information. The IBAC Act also puts stringent confidentiality conditions on the use of information. So information that is obtained in relation to an investigation cannot normally be simply used for other purposes. There has to be intervening steps for it to be formally, for instance, included in another investigation, right?
Sure, okay.
So it's a breach of my privacy rights and also a breach of the confidentiality provisions of IBAC for them to use the information that I gave for the second complaint in relation to the first complaint.
Okay, sure. Look, I confess I'm not familiar with the privacy.
No, so what I'm trying to explain, the relevance of all of this from the VI's perspective is that the IBAC, after understanding, after listening to me for several months in court hearings and understanding how I was going to attack them with a claim of misfeasance, about which I was very upfront, have concocted this elaborate fraud. And it is essentially to basically evade liability for its officers. But in the process, what they're doing is they're basically gambling with public funds and compromising the case that they're building against the police officers, because it is on a faulty, allocation of the decision to allocate resources in relation to that comes from a jurisdiction that they did not have.
I see, okay.
So that's the concerning bit, that they're using all of this thing, and it's now in full swing, the investigation. The investigator there's a lead investigator. I'm sure they have a team. They're using funds and so on and so forth. The other matter, by the way, is that I started the proceeding against the IBAC on the 23rd of November, 2022. Yeah?
Yep, 2022. Sure.
That proceeding alleged that they had done a number of improper things, or they had failed to perform their duty and so on and so forth. They were conflicted at that point. The IBAC Act requires them to notify the VI
Right, yeah.
if there is a conflict of interest. Now, I only told them about it a few months ago.
So you're referring to, just to clarify, so you're referring to the fact that you reported to IBAC that IBAC officers were engaged in improper conduct, yes?
That's right. And the same officers were then investigating the same complaints, which were made again.
I
I know. You received it after I told them that they should have.
Cool. Okay, I see.
And then immediately, so I told them earlier this year that apart from other things, they also failed in their duty to notify you about the conflict of interest. Immediately after that, they wrote to me and said that they have now notified you about the conflict of interest.
I see. Right. I'll make a note of this. Yes.
So, I mean, this is it's a concession that they should have always reported the conflict of interest to the VI. This was, 1.5 years too late.
Sure. Yeah.
Because my allegations against.
They should have.
Sorry?
I think yes, if it is the case that these allegations have been reported to us earlier, then yeah.
Yeah, because my allegations did not become more serious. The allegation was always the same. I mean,
Oh, I see. Okay. Yeah.
now they've become more serious because since then they have basically fraudulently uh, sought to reopen the first matter and abuse the judicial mediation forum and so on just to get out of the misfeasance claims. Now, so what essentially I wanted to clarify is that my first complaint to the VI was about how the IBAC had failed to consider the complaints properly and so on.
Yep. So it's just I've got it up here in front of me. You've got what we recorded as the basis of the complaint. Certain IBAC decision not to investigate your complaint for system interruption.
Yes.
Conduct made against the Victorian Police and the Victorian Legal Services Board of Commissioners Office. Second one is IBAC's failure to consider this recording information which is provided with you. I believe that in particular was the audio recording of Victorian Police on the day that they attended your property.
Mm-hmm.
And then IBAC's decision not to determine your complaint public interest complaint.
Yes. Now, my complaint now is far more serious, which is that they have abused the resources, relevant IBAC officers have abused the IBAC resources and their statutory duty to.
Sorry, just bear with me. I'm just typing this, so I'm trying to get it down properly. So IBAC officers have abused IBAC resources.
Yeah, and the statutory, let's say, entitlement or authority to effectively mitigate or evade personal liability arising from their failure to perform statutory duty. By the way, this also goes against the principle of indemnification for bail. So a statutory entity cannot provide indemnity to its officers for breach of statutory obligations. Because it creates an adverse selection scenario. Yeah, it's against public interest. It incentivizes people breaking the law. So the common law, it's actually a misdemeanor. It's called conspiracy. It falls under conspiracy to effect public mischief. So effectively, I've sent IBAC authorities on the subject, and I will forward that communication to you. But my complaint against the IBAC now is that they are they've done this the conspiracy to effect public mischief by abusing authority for personal benefit. This is personal financial benefit, by the way. But implications of that for me have been that I've been exposed to detrimental action for much longer. The criminal proceedings against me were dropped just before the IBAC came out with the decision, because once IBAC had reopened, the police officers were no longer willing to fabricate evidence and so on and so forth, and then they made admissions about all the things that they had hidden. So they stopped fighting subpoenas as aggressively, because to fight subpoenas they had to affirm false affidavits. And they stopped doing that, and then the evidence came out and the proceedings were dropped. So the continuation of the proceedings was just because the IBAC, for this long, was because the IBAC was unwilling to reopen the matter for this state, and the only reason they were unwilling to reopen the matter was because they were finding a way to get out of, the liability from the misfeasance suit. So back, yeah.
Because they were delaying this and they weren't treating your claim as a public interest disclosure of public interest claim, that was the detrimental action?
No. I'm saying because they were doing that, the police kept its proceedings on. So I have discovered communication, personal email exchanges between the ringleader at at Victoria Police, who basically led the invasion that day and instructed subordinates to fabricate evidence against me and Mishu, to the extent that she said that people should take goods from inside the house and load them into a truck and then argue that the truck had been full of stolen goods. Now that person, every time there were complaints raised about the informant in the proceeding or other people, she used the excuse that we were basically bluffing that we had evidence, because if we had evidence, the IBAC would have done something about it. There's constant communication where other police officers are getting worried about the allegations that we're making, and they remained allegations without evidence because they wouldn't take the evidence from us. So we would say, we have this evidence, we want to give this to you. They would basically say, no, we can't take this from you, this is not the proper channel, blah blah blah, and it'll come out in the proceeding when it does. And they would, that's right, and then they would then write to her and inform her about all of this happening, and she would say, that's just fabricated stuff. If they had anything, they would have gone to the IBAC with it. So when the IBAC actually opened the matter, the other police officers got very concerned, and they basically started disclosing the information that they had an obligation to disclose under the Criminal Procedure Act. And part of it was Justice Ganey also clarifying matters and the fact that the police had obligations and so on. So the combined effect of it was that, but the fact is that because the IBAC dragged the matter, now the IBAC had figured this out, that the complaint should have been investigated in the first place back in July or August at the very latest. And they made that admission to me during the mediation. The counsel, Mr. Brereton for IBAC, who was representing them, so Ms. Shu asked them why they had decided to reopen the matter. And they said that it was because of the evidence that I basically presented during the hearing, during the hearings rather, in the proceeding, which happened in July and early August. So,
July
2023. And by the way, 31st of July is when I had made the fresh complaint. 2023. And they didn't dismiss it. In fact, I hadn't even provided any evidence in support of that complaint because I had counted on the fact that through the court proceeding, they were on notice of all the information. So I'd really.
I think you did. I think this was this information you discussed with us in the last call.
Yeah, so the point that I'm trying to make is that there is now corroborating evidence that they perpetrated this fraud specifically for the purpose of figuring out a way to get out of the misfeasance claim for themselves personally, the IBAC officers. So they delayed, yeah, instead of immediately rectifying the issue and stopping the ongoing oppression that we were feeling, that we were facing. Sorry, they basically tried to play legal maneuvers, which weren't even executed with the necessary technicality as far as the law is concerned. But more importantly, they, even when they had no move left, legally speaking, they dragged their feet until they could concoct the mediation ploy to come out with. Basically, they thought that I would be sold on them investigating. So they also told me that they were going to investigate the LSPC because of obviously what happened was horrible and so on and so forth. The LSPC brought the reporter into the office and documented all of that stuff, the case files. So that was meant to be. Now let me clarify. They offered that as a bargaining chip while saying that it was not being offered as a bargaining chip. But they clearly said that would that. Oh yeah, it was direct. It was very, very. It was very obvious. So what they said was, this is what we're. If we were to indicate this to you, would that resolve the issues in the proceeding? And I said, it wouldn't, because as far as I'm concerned, I know that they have to investigate it anyway, and they will come out with a decision to investigate it very soon, because the only reason why they haven't done it up until now was that they wanted to try the mediation trick.
So you did say earlier, sources believe that they were attempting to bargain their statutory authority, something they were required to do.
Yeah, and they put it on the on a letter as well now. They've literally written to me and said that they reject.
Are you able to provide?
Yes, I will forward that to you after this call, the communication. I've also in that communication referred to the section of the IBAC Act which talks about liability for liability under tort law, and it clarifies that the liability in relation to that lies with the state. So, by the way, the IBAC did not even have authority to negotiate a settlement, even for itself.
Oh, okay.
That's my understanding. Obviously, it's a complicated area, but the liability is of the state and not of IBAC itself for the for misfeasance. So that would mean that all the funds that it receives for a specific purpose cannot be used for this purpose, because this is the state's burden.
Right, I see. Okay.
So in trying to negotiate an outcome for misfeasance, they're basically, again, I mean, because it's individual people that are doing it, they're engaging in an abuse of authority. And yeah, and I think the most consequential aspect of it, and also the most urgent aspect of it, is the allocation of all the resources of the investigation to that particular complaint. Now, what I'm concerned about. So the 19th of January 22 complaint,
Yeah, okay.
let's call it the first complaint. That's the complaint that has now resulted in the investigation. But as I pointed out to you, based on Bhardwaj and Cahill, that even if they did everything right, the police officers would have a reasonable argument to use the fact that they did not have jurisdiction to investigate them as a means of, thwarting the accountability efforts by IBAC. So I'm concerned that it's doomed to fail, or they're substantially jeopardizing its viability.
Right, I understand. So yeah, so you just to clarify, my opening sentence was just saying, you're essentially saying, are you saying they're aware that it's not really something that they're expecting an outcome from the appeal that they're...
No, I don't know. It could be that they haven't appreciated this aspect of the law, and
Oh, okay.
I'm going to write to them, this week. Tomorrow is the plan, to clarify that they should not do it this way, because it's a very I think that it's a fairly straightforward argument, based on the authorities that I've read. There may be some countervailing public interest considerations that may work on the side of not letting a serious criminal investigation be impeded by technical matters of that sort. But the issue is, why would they create an unnecessary complication when they already had an identical second complaint?
I see, yep.
So they had a complaint about the same issues, or they didn't even have, they could have raised a complaint internally. Under the IBAC Act, they're allowed to do that. So they can internally appoint an well, yes, they're basically someone from the IBAC who is aware of the matter raises the complaint, and then that complaint is investigated. So, but that's how you do it properly. What they're doing is they're compromising the case, and the only justification for it is that they want to have some specious argument in defense of the misfeasance claim that I'm imminently bringing against them. And because this is the doing of individuals, they have significantly jeopardized the IBAC's functions for personal benefit. Now, yeah, that's my allegation, obviously. In saying that, I'm saying that I've not heard them or their justification. But I cannot see a justification here, because I hadn't asked them to open the first complaint or to reopen the first complaint. Do you understand? So there's just no basis, and it doesn't achieve anything anyway, because there is no practical benefit of reopening the first complaint either. It's not like I'm getting that time back. And I've already made whatever argument could have been used in saying that, well, this will avoid the need for raising another complaint, is also moot in this case, because I've already raised the second complaint. And the other problem, well, they haven't told me what they've done with it. So, yeah, I haven't received an outcome. But, well, they've said that they're still investigating the other complaints. So I think they're including it in that general group. But I don't see why that would have done. And anyway, they had the facility to appoint an internal informant or I would have been happy to make a fresh complaint. Or they could have treated any of my future, any of my recent correspondences through which I complained about the police conduct as a fresh complaint. But this is now, there's a couple of things here. Firstly, I'm trying to understand whether, as per the VI process, I have to raise a new complaint about each issue, or whether it can be, investigated as a single thing.
It's a fairly complicated matter you're raising in the business matter. I presume that it can be treated as a single complaint, and my belief on
But both in relation to Victoria Police and LSB as well?
Well, so I was going to say to you, we don't have direct complaint handling over Victoria.
No. But the IBAC decision in respect of, so there's several IBAC decisions here.
Sure.
So
So
there's two kinds of let's say incremental issues. One is in the same complaint, there are different aspects of misconduct. So, for instance, with Victoria Police, one is they didn't consider the evidence. Two is they, closed the complaint in breach of statutory duty. Then they did not classify it as a public interest complaint. Then when they realized they had made a mistake, instead of focusing on their duty, they tried to abuse their office to, to evade personal liability of the different officers. Now, so whether all these issues can be included in one complaint is the first issue, and the second issue is then all of these things for the LSP, can they also be included in the same complaint?
I believe they can. What I'll do is I will double check that after I get off the phone call to you.
Okay.
But I don't think that they can't, particularly if they relate to the issues are essentially the same across both. Yeah, it's just the different agents.
But time frames are also a little bit different. They're like half a year apart. Would that affect anything? Half a year or 8-10 months? Okay. And then the other issue is.
Let me follow up for you, Rajesh. I don't want to tell you that it's all hunky dory and then we suddenly come back to you and go,
No, that's fine. That's why I'm.
I will follow up.
Okay. And then there's one more aspect to it. Does the VI handle complaints against individual IBAC officers?
We can. We typically take it as IBAC as a whole. You can certainly provide us information on individual IBAC officers and we will treat them as essentially an IBAC matter. Was there any particular reason that you wanted to?
Because the director of investigations so it's clear that they I had told them that I would sue them personally and clarified how and what the basis was, because misfeasance is a personal tort. Then they wrote to me and specifically said that they wanted release for the individual officers, and that was the purpose of mediation. And then now they have reopened the first complaint. So the individual officer stands to benefit, or is, taking a gamble to use that as an argument against the personal liability thing. And they're doing it at the expense of jeopardizing the success of the IBAC investigation. So that's basically no different from them, utilizing IBAC resources for personal gratification.
Sure, I see the argument you're making here. From our processes and we treat IBAC as a whole,
Yes. So it's the letter.
Pretty sure it's come under complaint.
Yeah. So it's the decisions, the first decision to dismiss, and then the decision to reopen the same complaint. They were made by the same officer. The the letter had the details. It was the director of investigations, Sue something. I will send you the information. Now, the second the second query that I had was that is there an urgent mechanism through which the VI can intervene in relation to the IBAC investigation? Because I'm concerned that they are, you know, setting themselves up for complication. And
Sure. So you're looking essentially saying that some type of injunction against the investigation.
well, it's more of a mandamus sort of thing. I want them to do their duty and, you know, not investigate the matter under the first complaint and rather investigate it under a new complaint. So,
So we don't really have that kind of power. Ours is an administrative oversight role. We don't have the power to tell IBAC to take any particular action. So we wouldn't be able to go to the complainant and stop them doing, or even to tell them to delay what we're investigating. That's not our power.
but do you have, in terms of the way in which you prioritize matters, do you consider the urgency or the possibility that your report may prevent foreseeable harm?
Sure, certainly I can. Yes, we do take into account matters that may be of higher urgency. Definitely.
Because this is not a matter that, you know, is just about enforcing accountability about something that has happened. This is a live matter,
I see. Yeah.
and
So yeah, essentially what you're saying to me then there's a ticking clock that would like us to prioritise this one.
well, firstly, I will write to them, and I think
Sure.
that it may be that they haven't picked up this aspect of the law. Secondly, I will start a proceeding against them for breach of my privacy or complaint to the information commissioner for misuse of information, and that will further, I hope, motivate them to reopen the matter. Essentially, what I want is that, you know, if this matter will be investigated for several months and will spend hundreds of thousands of dollars um, of the public resources and also require my input as a witness and so on and so forth, it should have a better possibility of succeeding. And you know, if 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 those complications arise later on, it will also increase the chances of IBAC giving up or coming to, you know, a without conviction settlement with the other people. So I don't want them to have these arguments in defense where, you know, basically there's no benefit to the investigation and there's no statutory imperative to use that particular complaint. So that's the thing. Anyway, I will write to them. I will also tell them that I'm raising this matter with you, and I will raise it with the OVIC if they continue. But I think out of all the issues, this is one of particular sort of urgency because even from you know, your knowledge of IBAC investigations, you would know that they would typically cost so many several hundred thousand, or you know, whatever the expense associated with an investigation of this sort would be, and then there's the public interest in making sure that the matter is prosecuted properly. And the investigation is now current and it's ongoing. And I mean, I'm not cynical to the extent of thinking that they want to throw this matter anyway. That's why there are not concerned about it one way or the other. But anyway, it's not a good sign that they're playing these games at the start of the investigation. Do you know what I'm saying?
Yeah, yeah.
So yeah.
Let's bring it back to the process. Now, those initial three allegations that you made about the decision not to investigate the corruption conduct complaint that you made, failure to consider the audio recording of the other information, and the decision not to determine the complaint as a public interest complaint, are those still afoot? Do you still want to?
Yes, yes, because in the original letter, I've gone through it carefully. They had specifically said that they had considered all that information and decided not to proceed with the investigation. So, yeah, and then the new issues are the more pressing ones. I would also add there that with for instance, the LSB complaint, which they had never considered, admittedly. This was made on the 9th of October 2022. All these years later, they've still not confirmed that it's a public interest complaint, which the statutory provision requires them to confirm as soon as possible. Their own website says that they do it within 4 weeks. They've still not confirmed it. And this is despite the fact that during the mediation, they basically told me that they were going to investigate the LSPC. And the counsel for IBAC, they said, because we can understand why it would be so upsetting. They had this reporter come in and record I mean, they were simply clarifying that they understood that it met the elements of the public interest threshold, public interest complaint threshold. But again, it is for dishonest purposes that they've still not classified it as a public interest complaint, and it continues to cause detrimental action for me and for the solicitor that they've basically improperly stopped from practicing. Yeah, so this is an extension of the other complaint that they're using they're withholding the performance of their duty for the specific officers for a dishonest personal gain, because in admitting these issues, they're trying to find an angle that they can argue, and in the interim, they're withholding the performance of their duty. Okay, so I'm sorry about not being able to get back to you on the last occasion. It was because
oh no,
yeah.
And I do apologize myself. I was away very, very unplannedly on the day, so I wasn't able to respond to your emails earlier.
Yeah.
But no, that's perfectly fine. We've got in touch now. So
okay. So I'll as I had foreshadowed, I'll send you some documents, and I'll send you a summary that will help you navigate them. And I'll definitely do it this weekend. So you'll have all the information you need, and I'll send you the email exchange that we had following the mediation where these matters were discussed today. Just yeah, so you can discuss it with people internally, and essentially, I think after you've had an opportunity to go through the material, maybe a week or so, if IBAC hasn't changed tact in respect of the complaint, then I will. I would like to speak with you or someone else from the VI again to see how the matter can be expedited. Yeah, but I mean, I'm not concerned about the investigation of all the complaints equally in terms of urgency. I'm only concerned about um, the fact that I think it will compromise the success of the investigation if it proceeds on this ground. But I will write to them as well this week to ask for reasons why they're doing it this way or that, not the other way, under the Administrative Law Act. Of course, I will keep you updated about that. Yes, and today, as I send you that correspondence, I'll also send you the initial rejection notice, and and I'll send you an affidavit of the principal lawyer of IBAC where they've summarized their position in respect of what happened to our complaints, all the complaints that we had lodged. It's mostly so it's factually, the things that are said are not factually incorrect. They've omitted some things which contextually makes it a little bit misleading, but it's a good starting position because it gives you an idea of how many complaints there were, broadly speaking, and what the outcome was, and the exhibits include the outcome letters as well, and the complaints themselves too. So I'm going to send you the mediation correspondence and the affidavit, and I'll also send you the notice of assessment outcome, the new one that they've sent, where they've said that they're investigating the matter, and the old one where they had said that they wouldn't.
Right. Yep.
There's no notice of assessment outcome for the LSB matter, because they had never opened it. So initially, let's start with this. There are some other documents I'll send in due course, but I think this is the urgent stuff that will give you context. Okay?
Yeah, that'd be great. Fantastic, Suresh. I look forward to receiving it, and then we'll close.
Okay. Thank you. Take care. Cheers.
No problem. You too.
Bye.